I'm back. I want to talk about AOBs and the fact that they are illegal in Texas. I'm Sharon Black. I'm a Texas public adjuster. I own Lady Justice Consulting Group. AOBs are an assignment of benefit, and sometimes, and this is, I think Florida allows them, Texas does not, they're illegal here. But a contractor can come in and say, hey, it's an assignment of benefits. I'll get your insurance proceeds for the work, so don't worry about it, I'll bill insurance. Well, in Texas, not only are those not legal, they're also roofers will call them contingency agreements. But the Texas Department of Insurance, the Texas Insurance Commissioner, has stated that that is a Class 3 felony. In Texas, you have to either be the homeowner to speak on behalf of your policy or argue it, or maybe your representative like a family member, a licensed public adjuster in Texas if you're working in Texas, or an attorney. So if you can be a public adjuster and own a contracting company, you just can't be the contractor and the public adjuster on the same claim, because the public adjuster works for the insured only, and the point is to have them arm's length apart. So if you're a contractor, and whether you're a PA or not, you're not the PA on that claim, you're not the policy holder, you are practicing law. And that's how Zell is an insurance defense firm, and that's how they have stated it. And eventually they said that they're going to do a class action where all these roofing companies in Texas get sued for doing this, and they see them. But I just wanted to say contractors have asked clients to enter into contracts whereby an insured purportedly grants the contractor a limited power of attorney to pursue the insurance claim on the insured's behalf. The consideration for acting in that capacity is to receive the proceeds from the insurance claim. So how Zell sees it is a sheep in wolf's clothing, in that you're asking for all the insurance monies, but there's nothing that says what you're actually going to do on that house, or that you're going to do everything that insurance says that they're going to pay for. Also, if the contractor negotiates a settlement of the insurance claim pursuant to that limited power of attorney, which is not an AOB in Texas, it's called the contingency, that salesperson will be in violation of the licensing requirements for public adjusters. In Texas, only licensed attorneys and licensed public adjusters are permitted to negotiate or effect the settlement of an insurance claim on behalf of the policyholder. And Lawn Smith and Associates versus Key, acting as an unlicensed public adjuster, can void a contract between the roofing company and the insured, and also void the contract, which is the policy between the insured and the insurance company. So what happened in Lawn Smith is he came along and he's like, oh, I'll handle your claim and you don't have to pay a deductible. At the time, the deductibles were not illegal not to pay them. They were part of the contract, meaning if we find damage, we will pay for that damage minus your deductible, but that's your portion, is you had to pay the deductible. So what happened was all these people were reported for not paying their deductible, and of course the attorney general's after them, and they're like, no, our contractor came out, our roofer, and this is in Fort Worth, said that we didn't have to pay it and that they would handle the whole thing and put our roof on. Well, some roofs got built and some didn't, so they were victims, and the Texas Attorney General came after them, and that's when they stated that they're not only illegal, void, and unenforceable, the contractor is engaged in unauthorized practice of public adjusting, which is called UPPA, but also unauthorized practice of law, and that's the State Bar of Texas. But of course, you can be turned in by the Attorney General. Anyway, those I just want to say, and everybody argues with me, Zell also goes on to say, and remember, Zell is the insurance defense firm. It heads up all of the, it lobbies for all of the laws that protect insurance companies in Texas. The second is, the law is clear that negotiating an insurance claim, even with a limited power of attorney, constitutes the practice of law. The Texas legislature has defined the practice of law as the preparation of a pleading or other document incident to an action or special proceeding, or the management of the action or proceeding on behalf of a client before a judge in court, as well as a service rendered out of court, which would be these, including the giving of advice or rendering of any service requiring the use of legal skill or knowledge, such as preparing a will, contract, or other instrument, the legal effect of which, under the facts and conclusions involved, must be carefully determined. So the courts are not constrained to that definition. They can also say, well, you're practicing law if you're not a public adjuster, because if you're the public adjuster, the Texas Insurance Code 4102 says, and 4101, you cannot be the insurance adjuster, you cannot be the public adjuster, and also be the contractor building back on that claim. So you can be an insurance adjuster, you can be a public adjuster, but you can't work on the same claim that you were contracting on. The Unauthorized Practice of Law Committee, the plaintiff had owned and operated a consulting firm that helped insurance settle personal injury and property damage claims with their insurance carrier pursuant to a limited power of attorney similar to this. And the committee filed a suit against that person and said, you're actually, anytime you settle, you're actually practicing law. So just recently we had big storms in the Spring, Woodlands, Tomball area, 82-mile-an-hour winds and up here on June 21st. And a lady that I knew, I reached out to her saying, hey, do y'all have any damage? Because there are 2 subdivisions up from me and we had trees on our roof. So she said, yes, my stepdad owns the house that, you know where it is, 2 subdivisions up, but the neighbor's tree fell on the house. And I was like, oh, I want to represent him on that, right? But then she comes back and says, well, it was the neighbor's tree and it fell on our garage, and it's a 3-car garage, and it just ruined it. And so I said, well, he can file on his own insurance company, and if the insurance company, once they pay you in full, they retain that subrogation right, so they can go after her insurance, her whatever, if that's appropriate. So she said, well, my stepdad didn't like, he was renewing with AAA or something, they went up to $3,500. He had a landlord's policy, and he thought he'd shop around, except he hadn't gotten around to shopping around, and it expired 6 weeks earlier. So I went over there, I said, well, that's a liability claim on the next door neighbor, maybe, but it really depends on if her tree was dead, dying, or diseased, because someone else's tree on your property is your tree, unless it's dead, dying, or diseased. So the neighbor across the street said, that lady who owns the tree, 2 weeks ago we had a big windstorm and it damaged her tree, and she came over and asked me and my husband if we would help her strap it to save it. And so she knew it had damage, but she didn't take it down or do anything to protect it from falling. And then this big storm came and it did fall. So I told him I really can't help him because I can only do first party breach of contract. First party meaning you're going after your own insurance. That's a third party under her liability. I couldn't do that because that's really a lawyer's thing. So he could go file his own. I told him what his language would be and what his facts are, because the lady actually paid to get the tree off of their roof, so she knew it was her responsibility. Anyway, I just said, if I were you, I would go and get a copy of that invoice from the tree guy who's removing the tree off your roof that she paid for it. So that's kind of an admission, whatever, that she knew that was her tree and it was damaged and it fell and it was her fault. And then secondly, make sure they take a picture of the tree. But then go to Allstate, because that was her insurance company, go to Allstate and file a claim. And the agent's office was around the corner. So I said, don't let them tell you, oh, we'll get back with you. You file a claim, they give you a claim number right then. So don't leave until you get it. But the bottom line is whether her insurance, he has to fight her insurance, or, even if I couldn't even file that claim, that has to go to a lawyer. Because it's a third party. That's the same as a car wreck. I can't do a car wreck. I mean, I can under my risk management company because I have an insurance adjuster license, but that's different. That's not me as a public adjuster. Anyway, I just kind of want to put that out there and know there's a lot of misconception. Roofers do it all the time. Insurance companies allow them to do it, but in reality, it is a third-degree felony for roofers to have you sign that contingency agreement, and also to call in your claim, help you call in your claim. I'll do another segment where the Texas Insurance Commissioner put out a bulletin, and I'll read that on my next one. See you later. Stay safe. Be careful.